Rule 121. New trial or reconsideration. Section 1. New trial or reconsideration. At any time before a judgment of conviction becomes final, the court may, on motion of the accused or at its own instance but with the consent of the accused, grant a new trial or reconsideration. 1a. Section 2. Grounds for a new trial. The court shall grant a new trial on any of the following grounds. A. The errors of law or irregularities prejudicial to the substantial rights of the accused have been committed during the trial. B. The new and material evidence has been discovered which the accused could not with reasonable diligence have discovered and produced at the trial and which if introduced and admitted would probably change the judgment. 2a. Section 3. Ground for reconsideration. The court shall grant reconsideration on the ground of errors of law or fact in the judgment, which requires no further proceedings. 3a. Section 4. Form of motion and notice to the prosecutor. The motion for a new trial or reconsideration shall be in writing and shall state the grounds on which it is based. If based on a newly discovered evidence, the motion must be supported by affidavits of witnesses by whom such evidence is expected to be given or by duly authenticated copies of documents which are proposed to be introduced in evidence. Notice of the motion for new trial or reconsideration shall be given to the prosecutor. 4a. Section 5. Hearing on motion. Where a motion for a new trial calls for resolution of any question of fact, the court may hear evidence thereon by affidavits or otherwise. 5a. Section 6. Effects of granting a new trial or reconsideration. The effects of granting a new trial or reconsideration are the following. A. When a new trial is granted on the ground of errors of law or irregularities committed during the trial, all proceedings and evidence affected thereby shall be set aside and taken anew. The court may, in the interest of justice, allow the introduction of additional evidence. B. When a new trial is granted on the ground of newly discovered evidence, the evidence already adduced shall stand and the newly discovered and such other evidence as the court may, in the interest of justice, allow to be introduced shall be taken and considered together with the evidence already in the record. C. In all cases, when the court grants new trial or reconsideration, the original judgment shall be set aside or vacated and a new judgment rendered accordingly. 6a. Rule 122. Appeal. Section 1. Who may appeal? Any party may appeal from a judgment or final order, unless the accused will be placed in double jeopardy. 2a. Section 2. Where to appeal? The appeal may be taken as follows. A. To the Regional Trial Court, in cases decided by the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court. B. To the Court of Appeals or to the Supreme Court in the proper cases provided by law, in cases decided by the Regional Trial Court, and C. To the Supreme Court, in cases decided by the Court of Appeals. 1a. Section 3. How appeal taken? A. The appeal to the Regional Trial Court, or to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its original jurisdiction, shall be taken by filing a notice of appeal with the court which rendered the judgment or final order appealed from and by serving a copy thereof upon the adverse party. B. The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its appellate jurisdiction shall be by petition for review under Rule 42. C. The appeal to the Supreme Court in cases where the penalty imposed by the Regional Trial Court is death, reclusion perpetua, or life imprisonment, or where a lesser penalty is imposed but for offenses committed on the same occasion or which arose out of the same occurrence that gave rise to the more serious offense for which the penalty of death, reclusion perpetua, or life imprisonment is imposed, shall be by filing a notice of appeal in accordance with paragraph A of this section. D. No notice of appeal is necessary in cases where the death penalty is imposed by the Regional Trial Court. The same shall be automatically reviewed by the Supreme Court as provided in Section 10 of this rule. E. except as provided in the last paragraph of Section 13, Rule 124, all other appeals to the Supreme Court shall be by petition for review on certiorari under Rules 45. 3a. Section 4. Publication of Notice of Appeal. If personal service of the copy of the Notice of Appeal cannot be made upon the adverse party or his counsel, service may be done by registered mail or by substituted service pursuant to Sections 7 and 8 of Rule 13. 4a. Section 5. Waiver of notice. The appellee may waive his right to a notice that an appeal has been taken. The appellate court may, in its discretion, entertain an appeal notwithstanding failure to give such notice if the interests of justice so require. 5a. Section 6. When appeal to be taken. An appeal must be taken within 15 days from promulgation of the judgment or from notice of the final order appealed from. This period for perfecting an appeal shall be suspended from the time a motion for new trial or reconsideration is filed until notice of the order overruling the motion shall have been served upon the accused or his counsel, at which time the balance of the period begins to run. 6a. Section 7. Transcribing and filing notes of stenographic reporter upon appeal. When notice of appeal is filed by the accused, the trial court shall direct the stenographic reporter to transcribe his notes of the proceedings. When filed by the people of the Philippines, the trial court shall direct the stenographic reporter to transcribe such portion of his notes of the proceedings as the court, upon motion, shall specify in writing. The stenographic reporter shall certify to the correctness of the notes and the transcript thereof, which shall consist of the original and 4 copies, and shall file the original and 4 copies with the clerk without unnecessary delay. If death penalty is imposed, the stenographic reporter shall, within 30 days from promulgation of the sentence, file with the clerk original and 4 copies of the duly certified transcript of his notes of the proceedings. No extension of time for filing of said transcript of stenographic notes shall be granted except by the Supreme Court and only upon justifiable grounds. 7a. Section 8. Transmission of papers to appellate court upon appeal. Within 5 days from the filing of the notice of appeal, the clerk of the court with whom the notice of appeal was filed must transmit to the clerk of court of the appellate court the complete record of the case, together with said notice. The original and 3 copies of the transcript of stenographic notes, together with the records, shall also be transmitted to the clerk of the appellate court without undue delay. The other copy of the transcript shall remain in the lower court. 8a. Section 9. Appeal to the regional trial courts. a. Within 5 days from perfection of the appeal, the clerk of court shall transmit the original record to the appropriate regional trial court. b. Upon receipt of the complete record of the case, transcripts, and exhibits, the clerk of court of the regional trial court shall notify the parties of such fact. c. Within 15 days from receipt of the said notice, the parties may submit memoranda or briefs, or may be required by the regional trial court to do so. After the submission of such memoranda or briefs, or upon the expiration of the period to file the same, the regional trial court shall decide the case on the basis of the entire record of the case and of such memoranda or briefs as may have been filed. 9a. Section 10. Transmission of records in case of death penalty. In all cases where the death penalty is imposed by the trial court, the records shall be forwarded to the Supreme Court for automatic review and judgment within 5 days after the 15th day following the promulgation of the judgment or notice of denial of a motion for new trial or reconsideration. The transcript shall also be forwarded within 10 days after the filing thereof by the stenographic reporter. 10a. Section 11. Effect of appeal by any of several accused. a. An appeal taken by one or more of several accused shall not affect those who did not appeal, except insofar as the judgment of the appellate court is favorable and applicable to the latter. b. The appeal of the offended party from the civil aspect shall not affect the criminal aspect of the judgment or order appealed from. c. Upon perfection of the appeal, the execution of the judgment or final order appealed from shall be stayed as to the appealing party. 11a. Section 12. Withdrawal of appeal. Notwithstanding the perfection of the appeal, the Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court, as the case may be, may allow the appellant to withdraw his appeal before the record has been forwarded by the clerk of court to the proper appellate court as provided in Section 8, in which case the judgment shall become final. The Regional Trial Court may also, in its discretion, allow the appellant from the judgment of a Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court to withdraw his appeal, provided a motion to that effect is filed before rendition of the judgment in the case on appeal, in which case the judgment of the court of origin shall become final and the case shall be remanded to the latter court for execution of the judgment. 12a. Section 13. Appointment of Counsel de Officio for accused on appeal. It shall be the duty of the clerk of the trial court, upon filing of a notice of appeal, to ascertain from the appellant, if confined in prison, whether he desires the Regional Trial Court, Court of Appeals or the Supreme Court to appoint a counsel de officio to defend him and to transmit with the record on a form to be prepared by the clerk of court of the appellate court, a certificate of compliance with this duty and of the response of the appellant to his inquiry. 13a. Rule 123. Procedure in the Municipal Trial Courts. Section 1. Uniform Procedure. The procedure to be observed in the Metropolitan Trial Courts, Municipal Trial Courts and Municipal Circuit Trial Courts shall be the same as in the Regional Trial Courts, except where a particular provision applies only to either of said courts and in criminal cases governed by the revised Rule on Summary Procedure. 1a. Rule 124. Procedure in the Court of Appeals. Section 1. Title of the case. In all criminal cases appealed to the Court of Appeals, the party appealing the case shall be called the appellant and the adverse party the appellee, but the title of the case shall remain as it was in the court of origin. 1a. Section 2. Appointment of counsel de officio for the accused. If it appears from the record of the case as transmitted that, a. the accused is confined in prison, b. is without counsel de part on appeal, or, c. has signed the notice of appeal himself, the clerk of court of the Court of Appeals shall designate a counsel de officio. An appellant who is not confined in prison may, upon request, be assigned a counsel de officio within 10 days from receipt of the notice to file brief and he establishes his right thereto. 2a. Section 3. When brief for appellant to be filed. Within 30 days from receipt by the appellant or his counsel of the notice from the clerk of court of the Court of Appeals that the evidence, oral and documentary, is already attached to the record, the appellant shall file 7 copies of his brief with the clerk of court which shall be accompanied by proof of service of 2 copies thereof upon the appellee. 3a. Section 4. When brief for appellee to be filed, reply brief of the appellant. Within 30 days from the receipt of the brief of the appellant, the appellee shall file 7 copies of the brief of the appellee with the clerk of court which shall be accompanied by proof of service of 2 copies thereof upon the appellant. Within 20 days from receipt of the brief of the appellee, the appellant may file a reply brief traversing matters raised in the former but not covered in the brief of the appellant. 4a. Section 5. Extension of time for filing briefs. Extension of time for the filing of briefs will not be allowed except for good and sufficient cause and only if the motion for extension is filed before the expiration of the time sought to be extended. 5a. Section 6. Form of briefs. Briefs shall either be printed, encoded, or typewritten in double space on the legal size good quality unglazed paper, 330 mm in length by 216 mm in width. 6a. Section 7. Contents of brief. The briefs in criminal cases shall have the same contents as provided in sections 13 and 14 of Rule 44. A certified true copy of the decision or final order appealed from shall be appended to the brief of appellant. 7a. Section 8. Dismissal of appeal for abandonment or failure to prosecute. The Court of Appeals may, upon motion of the appellee or motu proprio and with notice to the appellant in either case, dismiss the appeal if the appellant fails to file his brief within the time prescribed by this rule, except where the appellant is represented by a counsel de officio. The Court of Appeals may also, upon motion of the appellee or motu proprio, dismiss the appeal if the appellant escapes from prison or confinement, jumps bail or flees to a foreign country during the pendency of the appeal. 8a. Section 9. Prompt disposition of appeals. Appeals of accused who are under detention shall be given precedence in their disposition over other appeals. The Court of Appeals shall hear and decide the appeal at the earliest practicable time with due regard to the rights of the parties. The accused need not be present in court during the hearing of the appeal. 9a. Section 10. Judgment not to be reversed or modified except for substantial error. No judgment shall be reversed or modified unless the Court of Appeals, after an examination of the record and of the evidence adduced by the parties, is of the opinion that error was committed which injuriously affected the substantial rights of the appellant. 10a. Section 11. Scope of judgment. The Court of Appeals may reverse, affirm, or modify the judgment and increase or reduce the penalty imposed by the trial court, remand the case to the regional trial court for new trial or retrial, or dismiss the case. 11a. Section 12. Power to receive evidence. The Court of Appeals shall have the power to try cases and conduct hearings, receive evidence, and perform any and all acts necessary to resolve factual issues raised in cases, a. falling within its original jurisdiction, b. involving claims for damages arising from provisional remedies, or c. where the court grants a new trial based only on the ground of newly discovered evidence. 12a. Section 13. Quorum of the court, certification or appeal of cases to Supreme Court. 3. Justices of the Court of Appeals shall constitute a quorum for the sessions of a division. The unanimous vote of the 3 justices of a division shall be necessary for the pronouncement of a judgment or final resolution, which shall be reached in consultation before the writing of the opinion by a member of the division. In the event that the 3 justices cannot reach a unanimous vote, the presiding justice shall direct the raffle committee of the court to designate two additional justices to sit temporarily with them, forming a special division of 5 members, and the concurrence of a majority of such division shall be necessary for the pronouncement of a judgment or final resolution. The designation of such additional justices shall be made strictly by raffle and rotation among all other justices of the Court of Appeals. Whenever the Court of Appeals finds that the penalty of death, reclusion perpetua, or life imprisonment should be imposed in a case, the court, after discussion of the evidence and the law involved, shall render judgment imposing the penalty of death, reclusion perpetua, or life imprisonment as the circumstances warrant. However, it shall refrain from entering the judgment and forthwith certify the case and elevate the entire record thereof to the Supreme Court for review. 13a. Section 14. Motion for new trial. At any time after the appeal from the lower court has been perfected and before the judgment of the Court of Appeals convicting the appellant becomes final, the latter may move for a new trial on the ground of newly discovered evidence material to his defense. The motion shall conform with the provisions of Section 4, Rule 121. 14a. Section 15. Where new trial conducted. When a new trial is granted, the Court of Appeals may conduct the hearing and receive evidence as provided in Section 12 of this rule or refer the trial to the court of origin. 15a. Section 16. Reconsideration. A motion for reconsideration shall be filed within 15 days after from notice of the decision or final order of the Court of Appeals, with copies served upon the adverse party, setting forth the grounds in support thereof. the mandamus shall be stayed during the pendency of the motion for reconsideration. No party shall be allowed a second motion for reconsideration of a judgment or final order. 16a. Section 17. Judgment transmitted and filed in trial court. When the entry of judgment of the Court of Appeals is issued, a certified true copy of the judgment shall be attached to the original record, which shall be remanded to the clerk of the court from which the appeal was taken. 17a. Section 18. Application of certain rules in civil to criminal cases. The provisions of Rules 42, 44 to 46 and 48 to 56 relating to procedure in the Court of Appeals and in the Supreme Court in original and appealed civil cases shall be applied to criminal cases insofar as they are applicable and not inconsistent with the provisions of this rule. 18a. Rule 125. Procedure in the Supreme Court. Section 1. Uniform procedure. Unless otherwise provided by the Constitution or by law, the procedure in the Supreme Court in original and in appealed cases shall be the same as in the Court of Appeals. 1a. Section 2. Review of decisions of the Court of Appeals. The procedure for the review by the Supreme Court of decisions in criminal cases rendered by the Court of Appeals shall be the same as in civil cases. 2a. Section 3. Decision if opinion is equally divided. When the Supreme Court en banc is equally divided in opinion or the necessary majority cannot be had on whether to acquit the appellant, the case shall again be deliberated upon, and if no decision is reached after redeliberation, the judgment of conviction of the lower court shall be reversed and the accused acquitted. 3a. Rule 126. Search and seizure. Section 1. Search warrant defined. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. 1. Section 2. Court where application for search warrant shall be filed. An application for search warrant shall be filed with the following. A. Any court within whose territorial jurisdiction a crime was committed. B. For compelling reasons stated in the application, any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed, the application shall only be made in the court where the criminal action is pending. N. Section 3. Personal property to be seized. A search warrant may be issued for the search and seizure of personal property. A. Subject of the offense. B. Stolen or embezzled and other proceeds, or fruits of the offense, or C. Used or intended to be used as the means of committing an offense. 2a. Section 4. Requisites for issuing search warrant. A search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. 3a. Section 5. Examination of complainant, record. The judge must, before issuing the warrant, personally examine in the form of searching questions and answers, in writing, and under oath, the complainant and the witnesses he may produce on facts personally known to them and attach to the record their sworn statements, together with the affidavits submitted. 4a. Section 6. Issuance and form of search warrant. If the judge is satisfied of the existence of facts upon which the application is based or that there is probable cause to believe that they exist, he shall issue the warrant, which must be substantially in the form prescribed by these rules. 5a. Section 7. Right to break door or window to effect search. The officer, if refused admittance to the place of directed search after giving notice of his purpose and authority, may break open any outer or inner door or window of a house or any part of a house or anything therein to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. 6. Section 8. Search of house, room, or premise to be made in presence of 2 witnesses. No search of a house, room, or any other premise shall be made except in the presence of the lawful occupant thereof or any member of his family or in the absence of the latter, 2 witnesses of sufficient age and discretion residing in the same locality. 7a. Section 9. Time of making search. The warrant must direct that it be served in the daytime, unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. 8. Section 10. Validity of search warrant. A search warrant shall be valid for 10 days from its date. Thereafter it shall be void. 9a. Section 11. Receipt for the property seized. The officer seizing property under the warrant must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. 10a. Section 12. Delivery of property and inventory thereof to court, return and proceedings thereon. A. The officer must forthwith deliver the property seized to the judge who issued the warrant, together with a true inventory thereof duly verified under oath. B. 10 days after issuance of the search warrant, the issuing judge shall ascertain if the return has been made, and if none, shall summon the person to whom the warrant was issued and require him to explain why no return was made. If the return has been made, the judge shall ascertain whether Section 11 of this rule has been complained with and shall require that the property seized be delivered to him. The judge shall see to it that subsection A hereof has been complied with. C. The return on the search warrant shall be filed and kept by the custodian of the logbook on search warrants, who shall enter therein the date of the return, the result, and other actions of the judge. A violation of this section shall constitute contempt of court. 11a. Section 13. Search incident to lawful arrest. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. 12a. Section 14. Motion to quash a search warrant or to suppress evidence, where to file. A motion to quash a search warrant and/or to suppress evidence obtained thereby may be filed in and acted upon only by the court where the action has been instituted. If no criminal action has been instituted, the motion may be filed in and resolved by the court that issued the search warrant. However, if such court failed to resolve the motion and a criminal case is subsequent filed in another court, the motion shall be resolved by the latter court. N. Rule 127. Provisional Remedies in Criminal Cases. Section 1. Availability of Provisional Remedies. The provisional remedies in civil actions, insofar as they are applicable, may be availed of in connection with the civil action deemed instituted with the criminal action. 1a. Section 2. Attachment. When the civil action is properly instituted in the criminal action as provided in Rule 111, the offended party may have the property of the accused attached as security for the satisfaction of any judgment that may be recovered from the accused in the following cases. A. When the accused is about to abscond from the Philippines. B. When the criminal action is based on a claim for money or property embezzled or fraudulently misapplied or converted to the use of the accused, who is a public officer, officer of a corporation, attorney, factor, broker, agent, or clerk, in the course of his employment as such, or by any other person in a fiduciary capacity, or for a willful violation of duty. C. When the accused has concealed, removed, or disposed of his property, or is about to do so, and A. When the accused resides outside the Philippines.